25. Power to refuse to make decree without maintenance in proper case. Who is next? Is it your own? We just look this and reason. On the application of the respondent made in the course of the proceedings for a decree of dissolution of marriage, the court may, if it considered it just and proper in the circumstances of the case, to make a provision for the maintenance of the respondent or other provision for the benefit of the respondent, refuse to make a decree. Okay, I start again. On the application of the respondent made in the course of proceedings for a decree of dissolution of marriage, the court may, if it considers it just and proper in the circumstances of the case, to make provisions for the maintenance of the respondent or other provisions for the benefit of the respondent, refuse to make a decree unless and until it is satisfied that the petitioner has made arrangements satisfactorily to the court to provide the maintenance of other benefits as aforesaid upon the decree becoming absolute.
This one is self-explanatory.
Okay.
That where there is before the decree of dissolution of marriage will take place, especially circumstances where there are children. Because even though the marriage has broken down irretrievably, the issues of the marriage will have to be well taken care of. So the courts will not make such decree until there is a proper provision, either the party that has a stronger and financially, to actually show to the court that, okay, these are the steps we've taken to cater for either the wife, in Nigeria case where every wife in court requests for maintenance if the man has upper financial and okay, these are the provisions we made in place to make sure that even though the marriage has broken down irretrievably, before this dissolution of marriage is pronounced, the issues will be well taken care of, like to show to the court, okay, these are the positions we've put in place. Okay, I've paid the house for her if they were living together. I've agreed to pay so amount monthly before the court will bring the marriage to an end.
Okay. I'm also observing something there, that we have considered the fact that the decree, there is either both a decree nisi and a decree absolute. So a decree nisi might have been given, but between the period between which the decree nisi and the decree absolute is to come into place, the court can refuse to consider that decree absolute until the terms of the maintenance are established.
Complied with.
So as we go forward, we need to look at the circumstances to regularize a decree absolute.
So see situation where the decree nisi was given and the parties came to court with pregnancy wherein they should be together. In those circumstances.
No, that one is another circumstance where the court can say, in fact, the parties that say we don't want it absolute. And that's the essence of a decree nisi, to give them an option. An opportunity
to try again. And when you try again, pregnancy can come in.
No, normally first instance na pregnancy dey come. However, the constitution is that this period to check the maintenance is most likely between the period from the decree nisi to the decree absolute. It's just a confirmation whether the maintenance is being followed up on.
But my only issue is who follows up the decree nisi?
That is what I said we will look into as we go forward, because we, as one of the we will not jump any section. Otherwise, it's to research into that position now, because we have observed also that most of these decrees become absolute by the dispensation of time. By as time goes, it just moves from nisi to absolute. So we also see situations whereby the court did not declare the order as nisi. We are privy to the circumstance God gave the order for dissolution, decree of dissolution of the marriage. So we now consider it as nisi and also consider it absolute upon the infliction of time. But when we look at the laws, by the time we get to that section, we would have dealt with it.